Gill, representing myself, and I'd like something on the record. I wasn't given notice of this hearing. In fact, when I called it, we stumbled on the hearing by having Greg Federer just happened to look at my file a couple days ago. So if this court could show me where they mailed me that hearing notice, I would appreciate that. I'd also like this on the record that I called the clerk of court's office, and they said that the hearing was scheduled on November 17th, meaning scheduled for today, but made on November 17th. And I believe we have 10 days. So one, it isn't with the 10 days. It's, I believe, it was done so I wasn't going to be here. And I was going to default in this hearing because it was pretty clear that I was in Washington all last week and had to come here to make this hearing. So do you find that, Judge Delker, that they mailed me that notice of a hearing? Seeing you've attached my properties and my business account, I think I should be given a notice. I also want for the record that you've ignored our stay based on Corbell with regards on criminal, and I'm here to prove to you that it is being criminally investigated and at the highest levels.
So, Mr. Gill, with respect to your first point,
could you speak louder, Your Honor?
Yes, I'm sorry, sir. I'll use the microphone. With respect to your first point about the notice, in fact, I had concern about whether or not both parties would understand that this case remained on the docket because I received a filing that appeared to be an appeal to the Supreme Court from the summary judgment. So I was concerned that the parties might interpret that as this case was off this court's docket. So on April 18th, the clerk sent to all of the parties in this case specific notice that today's hearing remained on the docket and that the case remained on for trial. And that went to you and it went to the plaintiff in this case. So
can you show me where it went to me?
Well, I have.
I bet you don't have it.
I do in fact have it.
Right.
I got the order.
And why would the clerk say November 17th it was issued?
Well, I think this case, I'd have to go back and look, but I think this case was originally scheduled for this date back on November 17th.
Right, but if you're going to schedule a hearing on the 20th and have it on the 28th and not send me a notice, because my implication is that it was done intentionally, so I would default.
Well, that is definitely not the case.
Well, it's with Judicial Watch and we'll find out. And I would appreciate a copy of that
You can
notice.
Okay. The file will go back down to the clerk's office, and you can.
So you don't have it, Your Honor.
I do have it. I'm looking at it right here, but I'm not going
so
to.
So you are looking at the notice, Your Honor?
I am.
And you're looking at it that it was verified that it was mailed to me?
Well, I don't. It doesn't come with the verification. It has a CC to all parties, and.
Right, but I called the clerk of courts, and you know what they said? They did mail it to me.
Well,
so we've got a problem.
I can't tell you what the clerk of court told you. I have a notice that indicates it was mailed.
No, Your Honor, you don't have a notice that it was mailed. You see it CC. What you don't have is evidence that it was mailed to me.
Okay, Mr. Gill, you're here. I took the steps that I could take to make sure that you and the plaintiffs had notice of this hearing. This hearing has been on the docket for months.
Well, you dismissed the case, and now we've got a hearing on scheduling. I find that unusual, seeing I appealed your dismissal. Now we have a scheduling hearing.
Mr. Gill.
Did you dismiss the case, Your Honor?
I granted partial summary judgment. There are still issues that need to be resolved at trial, and that's why we're here today.
How did you make a summary judgment when you need to look at the evidence? You ignored the state criminally, and I'm here to prove to you, without a doubt, that it's being investigated by the FBI, the U.S. Attorney, and the DOJ.
Mr. Gill, the plaintiff, as the rules allow, filed a motion for partial summary judgment. You did not respond with appropriate affidavits to prove, excuse me, let me finish, to establish that there were facts to to establish the truth of the accusations with respect to the one count in this case, namely the accusation of defamation based on attempted murder. Based on that, Mr. Gill,
we asked this court, Your Honor.
Mr. Gill, this court is speaking. I will give you the polite response and an opportunity to state your case. I'm stating the court's position right now where we stand, so you will have the respect to allow me to finish and not interrupt me. Do you understand that?
I understand.
Okay, thank you. So, I granted summary judgment as allowed by statute and rule. You had an opportunity to respond to that. You did not. You certainly can appeal when this case is done if you think that that ruling is in error, but at this point, that issue with respect to that single count in the complaint is resolved. Now, there are other accusations of defamation in this case that have not been resolved. And the
attempted murder hasn't been resolved.
Well, it has been from this court's point of view. Mr. Gill, that issue has been resolved by partial summary judgment. I'm not going to argue with you about it. It has been resolved by the ruling on partial.
And you nerved the conflict between Shaheen, Divine Millimat has been my attorney. I have multiple settlement offers to them in the last few years for millions of dollars on these issues. We filed a stay that you ignored because we didn't want to give them the same evidence that you did in the drug trial and had all of our witnesses compromised. That was what you were going to do again. Your Honor, is there a reason why you didn't look or mention the stay that we put in prior to this? Prior to the hearing?
I ruled on the motion for a stay and denied it. This case is going forward. There is no basis in the law to stay this civil proceeding because you have filed a criminal complaint.
Oh, I have criminal evidence that we will turn into this courtroom.
That's fine.
Criminal evidence, Your Honor, you already have. You have text messages from a lawyer that is fearful of Alex Walker, who suggests about murdering my children and afraid of his own. Now, you have that. And then you're going to have to explain why you didn't recuse Divine Millimat, who's one of my attorneys.
Okay. I didn't make that ruling. That was made by Judge Rule.
Right, but you have the ruling, and it's based on fraud, and this is fraud. Are we to ignore that Alex Walker was my divorce attorney? With Judge Francois, $96,000 put me in jail. No. The DRA, with Judge Anderson, attached my assets. You know who was the attorney on that? Alex Walker. You see, this is these pieces that I'm being leveraged, and I'm being leveraged here. There was a motive to murder me. $50 million to murder me. We have witnesses. Brian Toomey's witnesses why Brian Toomey's in hiding.
Okay.
Get it? He was the contact for, excuse me, Your Honor, you said you let me speak. He was the contact for Alex Walker. Alex Walker controlled all these pieces, including the IRS piece, which we have. And that is with the Attorney General, that is with the Adjutant Generals, and it's also with the mail fraud. So in other words, these are being investigated. Brian Toomey is a witness. Isn't it funny that on this hearing almost 2 weeks ago, the county attorney drops embezzling off of Brian Toomey, so he can't be heard here. But Brian Toomey's involved in all of this and was a contact with Walker. When I went to Miami, only Brian Toomey and Kerry Lemieux, my assistants, knew where I was going. They gave that information. I got Brian Toomey. He confessed in tears and told me it was Kerry. But they were working with Brian, working with Walker. That's how they got my address. Now that is being with the police. And then Kerry Lemieux set me up again with Judge Francois Court. When I went to jail, here's the medical records and a letter from the attorney I met that morning that said, take the deal. When I said no, they tried to murder me. This is the evidence that they did. Again, the association with Walker. When I didn't take the $50 million settlement offer, they tried to murder me. So this case isn't done for murder. This is civilly. Why are we in court for drugs and murder where it should be criminally investigated? There is no deduction. I've got motive from Walker. I've got the accessibility of my records and numerous witnesses, paralegals, secretaries, by VP of the company will all say they took directions from Alex Walker. Now explain to me, in all these releases, they admit their guilt. The lion's share, with a group's global settlement, said that Divine Millimat was the lion's share of the guilt. These were their own attorneys, Attorney Hartley that represented Divine Millimat. There's no question of guilt. So think about this. We have clearly motive, because I wouldn't take their settlement, and I exposed them criminally. We have access to my employees. Brian Toomey had 10,000 text messages on his phone from 3 individuals. Me and Walker. That phone's with the U.S. Attorney, and so's his computer. And Kerry's computer is going to the Department of Justice in Washington. And you'd be fine that they're coordinating and mentioning Judge Francois, too, and Anderson. See? So this is corruption to protect the judicial corruption within this courtroom. Are we not paying attention that I'm in with Francois? Anderson, I got the next week for my septic, so we're going to kick him out of the house. We're going to freeze his assets so that we can't fight, that we can't show this corruption. There's no doubt with the evidence I have. And I'll submit all this evidence to you.
Mr. Gill, I made my ruling on this. You had an opportunity to submit this evidence. Already ruled on this. If you think I erred, you can appeal when this case is all said and done. You have a right to do that.
Well, I am filing criminally on this.
Okay, I understand that. But this case is the civil case. I need to resolve this case. So there remains an issue before we get to the issue of the trial that's pending here. Is the plaintiff has filed a motion for default with respect to the rest of the claims because of the lack of discovery that you haven't produced to them.
Well, we have a ton of discovery.
Well,
I was waiting on your decision, which you didn't give me one. And when we're talking about scheduling appointments, I find it unusual that I wasn't given notice for this one. I don't believe I was given notice for the other one either. See, this is how this court has been operating. And you're never going to find a receipt that mailed me that notice. So we're going to, and we're also going to file an appeal that you should never be hearing with Divine Millimat. Did you know they offered me $50 million? Why don't you ask them?
Okay, so Mr. Gill, with respect to your issues of notice, I am confident that you received notice of these issues because I know...
So if you don't show me a mailed receipt, where are we?
Please, let me finish. The process is the clerk sends out a notice. If the notice comes back as undeliverable, that remains in the file. There is no indication in this file.
The clerk says she didn't mail it, and she did it in front of 2 witnesses.
Okay, Mr. Gill,
Would you like the witnesses, Your Honor, that said that she didn't mail it? And she said it wasn't mailed, and it was November 17th. Because you're never going to find the receipt. But would you like the 2 witnesses to stand up and tell you that's exactly what was said? Which also brings us to a conclusion is, I believe that that's how the other dismissal happened. My paralegal, again, was poisoned. Now listen, we filed a complaint against her. She still has our computer and our evidence in this case. I had to duplicate so. Eileen Landing. The FBI knows about it, so the U.S. Attorney. See? So, if you'd like the 2 witnesses to stand up to say that your clerk said that to me, because I made a point to put it on speakerphone. Would you like that, Your Honor?
Well, so what, explain...
We weren't given notice on this one and the other one.
Of what? Well, you're here today, so...
No, we weren't giving notice.
Okay.
And the paralegal was poisoned. And now I'm going to show you that you didn't give a notice, and I'm going to show you that the clerk said that she didn't mail it. So we have a conflict. You dismissed my case on murder, where I didn't get notice. And again, we were going to have another case. It's a miracle that my assistant just walked into the courtroom and looked at something else. So that's what this was. This was all a performance, and I was going to be dismissed again. So, if the clerk says she didn't notice, you have to assume that it's possible that they didn't send me the notice before. So I think that these 2 witnesses that would be more than happy under oath tell you they heard the clerk say that. And that's exactly my intention. We're not getting a fair opportunity here. We have missed the fact that you had these drug dealers here too. Got 46 witnesses, released their information, and now we got Walker with attempted murder. None of this is civil. This is my life. Let's not forget, I have a disc of a man who was hired to murder me.
Mr. Gill, did you turn any of that discovery over to the plaintiff?
I asked this court before I did that Would you look at it this way? So when you turn around, that's what I was...
I'm asking you a question. Did you turn...
I looked for your guidance, Your Honor. I looked for your guidance based on Corbell with the date. Listen, I've got a tape of a hitman. He only did 9 years in federal prison for biting a guy's nose off and cutting his ears off. He only talks about distorting a guy with putting a chainsaw to his daughter's neck. Okay? He works for Auto Fair. Right? He talks about Andy Cruz, Sequoias, is the partner of these people. He's the one that... Now, you ready, Your Honor? I only got the courier from Auto Fair to New York and how the drugs come in and the money. No, I have that too. But you see, before we made the same mistake before, Your Honor, when you gave all that information out, I was going to give you an opportunity to have a stay so we can examine criminally this information. So when you didn't respond to me that way, then I didn't know. First of all, I didn't know the hearing. Your Honor, I would like you to put these two people in as evidence, as witnesses, because it is proof that I believe that this process has been corrupted, that I wasn't supposed to be giving notifications. And I didn't. Now, could we have those two people testify to that fact? Because I think this is grounds for your appeal.
Plaintiff's position.
Your Honor, we're here for a trial management conference. The issues that are before Your Honor...
Could you speak up, please?
The issues that are before Your Honor are well-defined. They have been the product of proceedings and pleadings to date. And what I would request is not that we go down some sort of a rabbit hole as to the notice issue, but that we actually address the issues that are before Your Honor, including the motion for the entry of final default, including my motion for contempt, and including figuring out how we're going to move the case going forward with respect to damages. On the issue of the conditional control, I just would like to make the point that there's no question that the defendants received my interrogatories. In fact, they filed a motion with the court to extend discovery, but then still never answered it. And for all of the blustering that's been going on this morning, there's no explanation for why the defendants can't abide by the court's rules, can't abide by the processes that are set in place for the procedures of a piece of civil litigation, which is it. And Your Honor, we're not dealing here with pro se's who are brand new to a courtroom or brand new to these processes. We're dealing with what is essentially a serial litigant, Your Honor. Someone who ought to know the rules by now, who does know the rules, and who chooses not to play by them. And so I really would ask the court, please do not have us go down some sideshows here and some tangents that really aren't relevant to why we're here today. And instead, we could just try to move through the issues that are in front of Your Honor.
Okay. Mr. Gill, let me ask you a question. What is your email address?
Excuse me?
What is your email address?
EdGill@themortgagespecialist.com.
Okay.
But
so Mr. Gill, I'm looking at a receipt that emailed these notices to mgill@themortgagespecialist.
And Eileen, Landy, was working and keeping those, so there was no notices. And listen, we have that.
Mr. Gill, I have proof in front of me that this notice was emailed to the email address you just sent.
I have email and it wasn't delivered. I don't believe it for a second. Listen, Your Honor, I have all this evidence that they can have. Did you ask them if they had a $50 million settlement? Maybe you want to ask them that. So my point being is that I wasn't notified properly. They'll tell you that the court said November 17. The clerk, would you like them to do this? I have two witnesses. I was looking for the court's instruction on the interrogatory and the evidence, as we did in the drug case, and you had none. And I asked the court for more time for that because I didn't want to turn over evidence. I'm prepared to turn over all this evidence, all the settlement offers. I can turn around and tell you the statements from multiple attorneys that are afraid for their lives. Maria Pizzuto, Dallas Sedgwick, Ted Little, and even his children. and they point out that they're afraid of Alex Walker. What did Maria Pizzuto did? She did the narrative that I have here of the crimination between Alex Walker, Bill Shaheen, and Liberty Mutual, working with Morris Mahoney to cover up all these crimes. In fact, Walker's been working with Brian Toomey for years. We have a case where Tom Morley and Curtis Morley, Tom Morley from TICA, was working with Curtis Morley, an accountant that I've never met before, who had the filings from the IRS for years under Walker's instructions. Now that is with the U.S. Attorney. There's no question of this guilt.
Your Honor, Mr. Gill, this is where things stand. I granted your request for an extension to turn over the discovery. I granted, you asked for 6 weeks. I granted 45 days.
And then I asked you to stay, Your Honor, because I found information that was trying to kill me.
Okay, Mr. Gill.
This is about murder, Your
stay.
Honor.
If you think those are errors, you will appeal those rulings. But at this point,
I have a dish, Your Honor, of the guy who's trying to murder me.
Okay.
You may want to listen to this. Would you like, I'm going to give you a copy, Your Honor. Could you give the judge a copy of this?
Mr. Gill, your time to submit that was in response to the motion for summary judgment.
Well, how about this? These civil pieces are motivated by this. So you know what? The fact that these people who were arguing the civil pieces, you want to argue? That's the motivation to kill me, Your Honor. So it is applicable.
Mr. Gill, I'm not going to argue with you. This is where things stand. You had an obligation to turn that over to the plaintiff. You did not. You had an
Our paralegal was working with them.
Let me finish. You had an obligation to submit sworn evidence in response to the motion for summary.
Proper notification, and I wasn't given it. And just like Francois, you know Judge Francois? We had another routine just like this. Oh yeah, you want to hear this? Eileen Landy told me a scheduling hearing. That was 2 weeks later. I was jailed, and they used $96,000 in bail to get into my business account with Anderson. See? Organized.
Mr. Gill, we're going to trial on May 8th.
Listen, I look forward to going to court. Forward. And I'll give you all this. I want that businesses unattached. They've attached payroll accounts.
Oh, but not on the murder charge.
Oh, yes, they did.
Okay, Mr. Gill, I'm not...
Well, wait a minute. They attached my accounts, Your Honor. Did you know that?
Yes, I did know that.
You do that. So you did that on what reason?
Based on a summary judgment, which...
So you're closing mortgage specialists down, right? And state of corruption, which you've been a prime suspect on. Is that what you're doing, Your Honor? Because you've done that.
Mr. Gill, I granted a motion for attachment because they have a judgment for partial summary judgment, and they adequately...
So you closed the business down, which is the intent from Francois. We got a ruling, we got a thing on the DRA from Anderson. Every leverage piece still goes back to him on the settlement for $50 million. Listen, this looks exactly what it is. This is extortion. All the judges have done it. Now you've attached accounts. So you managed with Francois, empty our account, Anderson, take the rest of the business, shut down state of corruption, and if we had a little life left, you took care of that. And all while Eileen Landy was working for me, now she'll turn state's evidence. So we're going to find all this out. But that's a coordinated effort. So you closed a company that was open for 29 years. Did you consider all the employees that worked for me for over 20 years and their families?
Mr. Gill,
Can I have an answer, Your Honor?
Mr. Gill, that's not the issue here.
Oh, it is the issue, Your Honor. You just managed to close down mortgage specialists and the ability to fight back with state of corruption. That's exactly what you did. From a person that offered me $50 million. On all the pieces I'm being leveraged on.
You can yell at me all you want. The plaintiff has brought a claim in this case. They have supported that claim.
And I'm prepared to answer all that claim.
You have presented no evidence to contradict that claim under...
This is all evidence. We were waiting for you to turn around and protect these witnesses, just like you didn't in the last case. So now, listen, you're playing with the same ball and the same game plan. It's pretty obvious. And Judicial Watch is looking at it too. In fact, I had to cancel a meeting to get here. But I'll give you all this, and you can explain the attempted murder. You can see that each and every one of these witnesses, because it is all civilly, because they were worried in their discovery of civilly, the fact that they were in danger catching Walker and Shaheen. Now, we have multiple attorneys that I will give you, and that are involved in this case, that were worried about their lives. Have you ever heard any of them say that they didn't offer me millions of dollars in a settlement for all the same issues I'm being leveraged with on the table right now? So if you don't think $50 million is motivation to murder, you're wrong. See, you know what happened? Walker, Brian Toomey, and Carey informed them I was going to the National Mortgage Association. Walker was a banking attorney. That's how I met them. So by protecting the banking department, for instance, Implode, I sued them. He never gave me the information that we won. And guess what? Right in his courtroom. See? He was covering for the banking. When they found out that I was going and filed criminally against the banking, Brian Toomey gave him location. And I had a man break into my room. And the police did come. And security did come. And they've been covering that up. Still, with Eileen Landy and Carey with the information on instructions from Walker.
Mr. Gill, this is what I'm doing. I'm granting the motion for final default judgment. It is obvious to me that you are not following the court's rulings in this case with respect to the discovery.
Default judgment? I'm giving you all the information here. I'm prepared to give you this evidence. You will not take two witnesses that gave us a contradictory date. You won't take them as evidence, and I want this on record.
It's on the record. You have your...
No, it's not on the record. They come up and swear and tell you what they heard, then it's on the record. Is there a reason why you won't want to do that?
Because I have the notice in front of me that indicates that the notice was sent to you, it was emailed to the address that you gave me here.
It is belonging, just like they did with Francois. They gave it to Eileen Landy. This is criminal. Listen, are we supposed to pretend I have a divorce hearing there? Anderson on 3 different cases with the DRA, all Walker, and now you here, who just had the drug dealers before, took all their information, right? They've been then later threatened, and now you wanted to do this in the same case here. You never asked on the stay, and I asked you for time to do that, to review this information. Now I'm telling this court in evidence, you have criminal information. You had a conflict on the Shaheen with Rosenberg. Walker was working with Rosenberg. Lisa Tracy will testify to that. Ted Little, on the text, the gentleman who was afraid for his life, that's exactly what he said. Lisa and Brian Toomey. And the reason why? This is why we have to have a civil case. You'll love it. Have them explain why they're offering me millions of dollars. So, Your Honor, so your last judgment is you're going to freeze the account and mortgage specialist.
Mr. Gill, I've heard
Are you closing the company, Your Honor?
Mr. Gill, I've heard you out. I'm going to give the plaintiff an opportunity to address the court.
Wait a minute. Did you make a ruling to freeze the company's assets?
Yes. And
so you closed, so you're saying you closed mortgage specialist?
I granted an attachment in this case.
So we have no payroll. We can't pay. So we're going right to the governor and letting him know how you're closing it down in a judicial watch. And listen, do you know all about this criminal evidence?
Okay, Mr. Gill.
I gave it to him personally, and we put it on video. So there isn't anybody who doesn't know what you're doing. You were friends with Van Ostrin, best buddies with Rosenberg, who coordinated this with Walker. This is why you have the case. Listen, I'm filing criminally, and I have against you.
I understand that. That's fine. Attorney Dan Will, what is your position? So, in light of the lack of discovery in this case, I'm going to grant the motion for final default judgment. What's the position about the damages component of this case?
Thank you, Your Honor. So our view is that at this point the case ought to proceed pretty much pursuant to Rule 42. What we would request, and I put it in a pleading that I filed earlier this week, we would request that the court take this off of the jury list for May, and that we proceed to a damages hearing prior to which we would file an affidavit of damages and any other relevant plea, perhaps a memorandum of some kind.
Could you speak up?
We think that...
Yeah, please keep your voice up.
I'll do the best I can. We think that a day would suffice for a hearing from Your Honor. If that can be done sometime in May or June, that would be terrific.
A stay?
From our...
No, a date. He's saying one day.
One day. So, and that's laid out, Your Honor, and I filed a pleading entitled Notice of Jury Waiver and Request for Proceedings on Damages.
Well, so the one thing I didn't couldn't tell in this case is, did Mr. Gill also request a jury trial in his answer?
He did, Your Honor. He did. And I cited to you law, and I've got a couple more cites I'll give you for the proposition that a party who defaults waives his or her right to make that demand. And so I've cited to you Preston versus Shea case, which was a Massachusetts case cited with approval in a State v. Thompson in a criminal case in New Hampshire where that was actually enforced. But like I said, there's some other cases as well that stand for that proposition. So at this point in time, from the defendant's standpoint, that right is waived. And so
well, if the default is on the one part of the case, but not all parts of the case, does that automatically result in a waiver of the jury trial on those parts that aren't defaulted?
I think the default, Your Honor, is with respect to the entire case. It's a motion for the entry of default judgment on the case, not on a particular piece of the case arising out of the discovery failures.
So, Your Honor, are we saying the case was dismissed in full? I mean, this is not the time, seeing you seized my assets, to be questioning that. Right? Because that would put the appeal in place, which was not its intention, now was it? But to attach the property. See, they don't want to go over all the case. They offered me $50 million, Your Honor.
Okay, I'll take that under advisement. I have to take that under advisement and make a ruling.
So are you releasing the thing? So if it is in full, then I expect this to be a release because I appealed your judgment.
Okay. And I've ruled that at this point that is an interlocutory appeal, and until there is a final ruling on all issues.
Right, so you're trying to starve the company out. So in other words, they don't want to go and evaluate the evidence. They want you to make a dismissal, wait, and you freeze the appeal to put us out of business.
All right, I understand your position, Mr. Gill. I'm going to issue a...
No, I'm telling you, Judicial Watch in America understands my position. Okay. And the corruption that goes through this courthouse, in the courthouse, people understand. Listen, there's a train coming right over you.
Mr. Gill, I'm going to issue a written ruling with respect to the issues that are pending before the court.
And what's that, Your Honor? You already know what you're going to do, right?
No, I don't know what I'm going to do.
Oh, really?
Okay.
But you are going to stall, so your order stands, even though your order was contrary to what they said on the dismissal. The dismissal is, Your Honor, you got to get on the same page. They don't want you to see this. See? So we have our paralegal that worked with them. Not one, many. That's how these things happen. For me to be here was a miracle.
Right. You've said that several times.
Well,
I understand,
but I want you to acknowledge that you are closing the company.
Okay, Mr. Gill, I'm going to issue...
Did you freeze all the assets of the company, Your Honor?
Mr. Gill, I've already expressed the rulings I've made in this case. I'm going to issue a written order with respect to the remaining issues prior to the May 8th date in this case, so the parties know whether this case is going to trial or not on May 8th.
So, would you like to review all the evidence, Your Honor?
Mr. Gill.
Well, wait a minute. If you want to make a decision, Your Honor, don't you want to make a decision based on knowledge? How would you like to see some of this evidence that I have, Your Honor? It's okay, right? You're going to put it under review. Don't you want any consideration?
Why did you not present that evidence?
Because I wasn't notified the paralegal that was working for me. Listen, how many times did I got to tell you that?
Okay.
Eileen Landy and Kerry Lemieux before that. Bill Turn states evidence. In fact, you'll see some judges go into jail.
I hear what you're saying.
So, are you saying you don't want the evidence, Your Honor?
At this point, I'm going to issue a written ruling that outlines all of the issues that are currently before the courts. And we'll receive a copy of that ruling. And at that point, I'll address your issues.
So you're not going to take, so let's tell everybody, you are not going to take any evidence that would prove them with even killing me. You don't want any of that.
Mr. Gill,
is that what you're saying?
Mr. Gill, I'm taking these matters under advisement, and I will issue a written ruling.
You close mortgage specialists, you close state of corruption, you refuse to take the evidence, You refuse to say witnesses. You haven't asked them if they offered me $50 million for that same corruption.
Mr.
Right.
Hill, this hearing is concluded. I will issue a written order.
Going to jail.
They are like that.
I promise.
They want to take down
The world knows what's happening here. I'm going to post all this on the internet. Show everybody what you didn't take.
You have a right now to the 5 days.
Do you want to hear from a guy who was paid to murder me? Mike Gill, just get out of court. That was an orchestration. We weren't given notices. They even knew I was in Washington. I wasn't supposed to show up.
All right, so that's done.
They can't argue this, right? Remember I said Francois in this courtroom, the other judge, getting me into jail to take out the money, to turn around and have Anderson in the same courtroom, do the same with Wiggins and DRA. These are the cases that were walkers on. Did you hear them again say they denied the $50 million? These are the pieces they were leveraging me on. And that was the motive for my murder. Remember the banking commission? Laundering? In fact, the drug dealers were in the fucking courtroom with us today. Right, with the same judge. This is a complete orchestration. And they had to close state of corruption. Did you hear that? Yes. And then when we wanted to have a trial, jury trial, they're saying, we argued the jury trial, they did. Then they said, we don't want a trial, we don't want anything, we don't even want the evidence. We want a complete dismissal. You see, it was all corrupt. Delker has to make the decision or that bastard goes to jail. He's trying to save his ass. And the only way we turn around and they save all those judges, those drug dealers, those attorneys, is to shut state of corruption down and mortgage specialist that funds it. You see? Well, we ain't dead yet. In fact, assume that I will never quit, ever. We just have to find other means, and I will. But what you saw today was the corruption in this court that goes through all the state of New Hampshire and goes through state courts throughout this country. This model in New Hampshire would turn around and improve the corruption at its highest levels, but more importantly, how they do it. Then we take this model and we go across this country. We start a state of corruption in every state. Mike Gill, state of corruption.